Hi, I'm John McGowan. I'm the General Secretary of the Social Workers Union. Good evening and welcome to another SWU webinar where social workers get the opportunity to ask employment-based questions, all free of charge, of course. It's great once more to see so many people registered, and I can see a large number of attendees for tonight on the screen. I don't know about you, but it's pretty windy and wet in Edinburgh out the window, so hopefully you have better weather than I have got tonight. I am hopeful that we'll get through quite a lot of questions this evening, and do remember that the advice offered for this session is as today's date, which is the 31st of March 2021. The event is being recorded and it will be available to review and share very soon after this event. Working hard behind the scenes are the talented Jane and Lisa, and I will now take you through some of the housekeeping for this webinar. Please ask any questions in the live chat box, which will be to the right of the webinar screen, and Jane and Lisa will make me aware of them to share with the panel. There are also a couple of handouts advertising the SWU assignment competition and another BASWA handout, so please do have a look at that. My advice is really to keep any comments very brief and non-identification factors, just to represent confidentiality. Before I introduce the panel, I just want to emphasise the need to join a trade union. Of course, I'm biased. I would always recommend that you join the only specialist social work union, which is of course SWU, and SWU working with BASWA is indeed a terrific collaboration for the social work community. Now, over to the most important people in this webinar, and I'll ask each panel member to introduce themselves. Before I do this, unfortunately, one of the panel members could not take part tonight, and in true social work style, the show goes on. So I'll ask Paul to unmute himself. And Paul, if you introduce yourself, please.
Thanks, John. Thanks for inviting me to speak at this panel tonight. My name's Paul Scoley. I'm the senior partner of trade union legal firm Morrish Solicitors LLP. We are based in West Yorkshire, but we represent over 20 unions throughout the UK. And my particular interest is in employment law, which is what I hope to talk about tonight.
Thank you, Paul. And Laura, would you like to introduce yourself, please?
Good evening. Yeah, my name is Laura Sheridan. I'm a SWU trade union official and work for the BASWA Advice and Representation team as a BASWA Advice and Representation Officer.
Thank you, Laura. So what I'll do is I'll be, as I said before, I'll be checking the chat box, so keep any questions or any chat coming in. And we've had a question in previously, and this is a good one for you, Paul, really. It's, if you wouldn't mind starting with this one. It says, what are the issues surrounding discrimination based on religious and philosophical beliefs? So what are the issues surrounding discrimination based on religious and philosophical beliefs? Over to you, Paul.
All right, thanks, John. It's an interesting subject. There are many what we call flavours of discrimination. People are more commonly familiar with discrimination on the grounds of sex or race or disability, but increasingly we're seeing cases brought by employees and workers who say that their employers have treated them badly or differently on the basis of their religion or belief. So what is religion and belief in law? Well, religion is fairly well readily identifiable. All the mainstream religions are included: Christianity, Hinduism, Islam. All of these things can amount to, of course, a religion, and that would apply even to some of the less well-known religions. But where the tribunals and courts have had to grapple with a more complicated legal issue is what amounts to a philosophical belief. And the law was decided most recently in a case called Nicholson and Granger, where a set of rules were laid down for determining whether a given belief might amount to a philosophical belief for the purposes of discrimination protection. And there is a manifold test, or a multivariate test, that determines whether a belief can have the same quality as a religion. So the tests include, for example, whether the belief is of a serious and cogent nature, whether it is worthy of respect in a democratic society, whether it is genuinely believed by the claimant. And these tests have been applied now in a host of sometimes quite bizarre cases, looking at what amounts to a philosophical belief covered by the regulations. So we have cases that say that a belief that fox hunting is bad might be a philosophical belief, and you could be protected for expressing views about that belief. A belief about the importance of environmentalism has been covered. A belief about the purity and importance of public service broadcasting. So somebody who dedicated their life to the BBC was able to persuade a tribunal that that belief represented a philosophical belief for the purposes of this protection. More recently, and perhaps quite topically given recent events, one person tried to establish that loyalty to the flag was a philosophical belief, but the Employment Tribunal gave that short shrift. Likewise, the BNP tried some years ago to establish that their particularly obnoxious brand of repatriation philosophy should amount to a protected belief, and the tribunal gave that short shrift too on the basis that it was not a belief worthy of supporting a democratic society. Republicanism, Marxism, creationism, Darwinism, but we've got to a point where, provided that the thing is genuinely held and is not regarded as frivolous or trivial, then it might be protected. And my favourite argument that I've seen I've yet to see to be made about this, but I'm desperate to run a case if somebody's interested, is for the Pastafarians who believe in the great spaghetti monster. And of course, the whole thing appears to be frivolous and entirely trivial until you realise that in fact they're making a perfectly important and relevant point, which is that if you can believe in a Christian God, then there's not a lot of difference in believing in a great spaghetti monster. So they're actually making quite a serious point about how different religions should be tolerated differently. So I'm really hoping that a Pastafarian will instruct me to pursue a discrimination case for them. So I hope that covers some of the issues that question raises, John.
Thanks, Paul. Excellent answer, and well done. Laura, have you got anything to add to that question?
Yeah, the only thing I would add to that, just to kind of, I suppose, expanding on that a little bit, is in terms of religious belief and discrimination, under the Equality Act, an employer would always have a defence of what's called or quoted as a proportionate means of achieving a legitimate aim. And I think to provide an example of that in context would be if a nurse was wanting to wear a particular religious symbol, item of jewellery, for example, in her daily duties, the hospital could potentially say, well, no, we don't allow jewellery for infection control. And that would potentially not be religious discrimination because it's a proportionate means of achieving a legitimate aim. And that there has been similar case law around that. So it's about looking at the law as a whole, I suppose, and that's another issue in relation to that.
Thanks, Laura. I'll go on to another question. We've had a few more questions in, but the next question's got, my team manager post has been deleted. This is for you, Laura. My team manager post has been deleted following a restructure. I have successfully interviewed for a ring-faced post and received a letter from HR stating that this post is being considered as suitable alternative employment. What does this mean for me? So I'll read it from the top again. My team manager post has been deleted following a restructure. I have successfully interviewed for a ring-fence post and received a letter from HR stating that this post is being considered as a suitable alternative employment. What does this mean? Over to you, Laura.
Thank you. So in redundancy situations, generally, there is something that is referred to as reasonable alternative employment. What that means is that this employment must be what's classed as objectively suitable and must be equivalent or substantially equivalent to the job that you were already doing. So it must be a similar kind of role, similar terms of conditions, and similar grade, for example, to what you were doing. And if that isn't the case, then that wouldn't be considered reasonable alternative employment. Now, if somebody refuses an offer of reasonable alternative employment, then they would potentially lose the right for a redundancy payment, but that depends very much on the situation, and there's a whole host of case law around this issue. But for example, if a situation is to progress to a tribunal court, they do take into account things, subjective matters, for example, the person's experience in the job, any personal problems, health issues, travel facilities. So if somebody's relocated a long way away and they can't actually travel to get there, that would be classed as potentially not reasonable in terms of an alternative employment. And even things like childcare and children's education could be considered if it's going to significantly impact on that. So in terms of how this works in practice, the employee should always be given a reasonable amount of time to consider the offer of reasonable alternative employment, and they should be given the details of it in terms of the details of the new employment and how that compares to their current contract and their current employment. So they're the general principles around that issue. And what I would always say to people is, if you're in that kind of situation, I would always contact our team to get specific advice on your situation, because it is very specific and individual to that person's employment situation.
Thanks, Laura. And Paul, anything you would like to add to that particular question?
No, it's a really good answer by Laura. I'd simply say, if you're offered an alternative that is effectively the same job on the same terms and conditions, and you don't take that, then chances are you might well lose your redundancy payment. But of course, in the real world, it's very rare that you're given almost the same job on the same terms. There tend to be differences. So that's all I'd add.
Thank you, Paul. And if you stay with me for this one, I'm just going to read it off the screen here. So it says, I've been offered a different role as an alternative to redundancy. Will I still be entitled to a trial period of 4 weeks if during that trial period my employer and I agree things aren't working out? Will I still be entitled to a redundancy payment? So I read that once more from the start. It says, I have been offered a different role as an alternative to redundancy. Will I still be entitled to a trial period of 4 weeks? If during the trial period my employer and I agree things aren't working out, will I still be entitled to a redundancy payment? Over to you, Paul.
So that follows on from what Laura was saying before, and what I touched upon, where the job that's offered as an alternative is materially different, and that might well be in terms of location, or it might be that the actual work that you're doing is different, or it might be that there's some other fundamental difference in terms and conditions, or the way in which you're employed, then that's not automatically going to replace your old job, and potentially you have a right for redundancy payment. You get a 4-week trial period, during which you and your employer can see whether the new work is really suitable. And if you don't feel that it is, then you can walk away during that period, and you can retain your right to a redundancy payment. The trick is that you need to take that decision within 4 weeks, because come week 5, if you continue to work, then the potential redundancy, we say in legal terms, disappears. So there was no longer a redundancy. Your right to a redundancy payment disappears, and you're stuck in the new job. So you need to make a decision fairly quickly.
Thank you, Paul. And Laura, was anything you want to add from your perspective as a very skilled trade union official and A&R officer?
I don't think I can add anything that Paul hasn't already said, really. I think he's answered that question fully.
Thanks, Laura. So since you're next on the list, Laura, I'll read this one out to you. It's quite a topical one, actually. So who would say that COVID would be such a topical question a couple of years ago? But it says, can my employer require me to be vaccinated against COVID-19? And can my employer require me to work with someone who hasn't been or won't wear a mask? So over to you, Laura.
There are two separate questions there, although they're interlinked. So I'll cover the vaccine issue first. This issue is a little bit of a difficult one because we've got very limited, well, virtually no case law in terms of how the courts are going to view this moving forwards. Our inclination and our thoughts on this as to how it will be viewed is that actually, is it reasonable for the employer to expect staff to be vaccinated? And if you're a frontline key worker working with people who are vulnerable, it could easily be argued, we think, by the employer that it would be perfectly reasonable for them to expect their staff to be vaccinated and actually require them to do so as part of their, a duty for them to do so effectively. Ultimately, this is going to be decided by the courts, and it will be on a case-by-case basis. I think somebody in a different role to social work, the courts may view this differently, but I do think generally social workers will be likely to be expected to be one of those key workers that would be vaccinated. I think if you had particular concerns about vaccination, and for example, if you weren't able to have the vaccine, for example, if you were pregnant and it wasn't recommended for you at the moment, that is a different scenario. And again, I would advise people to get in touch with us to talk their individual situation through, because every individual situation is different. In terms of requiring you to work with somebody who isn't vaccinated, again, there's no case law around this. We're really, I suppose, guessing at what the courts are going to view this, but that's quite a tricky one because there's confidential information here. How would you know that person hadn't been vaccinated unless they told you? It's not that the employer shouldn't be giving you that information because it's confidential. And I think it is all around health and safety and risk assessments of that situation at the time. How risky is it for someone to be working in that situation? If you're not working in close contact with that person, if that person is mainly home-based, there's all those. It's about individual risk assessments of that particular situation. And I think that comes down to the same in terms of people not wearing a mask. Some people can't wear a mask because they have exemptions and medical conditions that mean that they're not able to do so. But actually, again, the employer has a duty to do a proper risk assessment of that situation and look at ensuring that the person who isn't wearing the mask, isn't able to wear the mask, is that there's a correct social distancing, there's ventilation, and actually really risk assessing that whole situation. Does that person need to remain working at home for longer than colleagues, etc., etc.? So it's about really assessing the individual situation. And again, I would urge people, if they're in that situation and it's concerning them, because it is a clear health and safety issue, come to us for advice and we'll talk you through it and offer you that advice and representation if needed.
Thank you, Laura. And Paul, was there anything you want to add to that question?
It was interesting to see Chris Whitty say just a week or two ago that in relation to NHS practitioners, he described that being vaccinated was tantamount to a professional duty. And as Laura says, I think the more public facing you are, the more likely that sort of argument's going to be made. I think we're finally seeing a few cases, not about vaccine yet, but about PPE, for example, coming through to the tribunal. So literally just in the last few weeks, a tribunal has decided a case in relation to a lorry driver employed in London to deliver to a customer of his employers. He turns up on the customer's site in his cab, pulls his lorry up to be unloaded, and he's told, you've got to wear a mask. And he says, I won't wear it. The cab is my workplace. I can decide what I do in my workplace. But the warehouse operators say, no, you're in the worst possible place. You're up in the air with an open window where the ability to spread the virus and to spread saliva and so on is enhanced because of your elevation. Get off the site. Net result, his employers discipline him and he's dismissed and pursues a claim for unfair dismissal. And we've got the tribunal decision now. The tribunal said he was fairly dismissed in those circumstances. The employer had given instructions about complying with health and safety requirements in relation to COVID on site. He'd failed to do so, and it was reasonable, therefore, said the tribunal, for the employer to dismiss him. We've also now got two, I think, High Court decisions relating to people in care homes who can't make decisions for themselves because they lack capacity. And I think both of those cases now have gone in favour of the High Court judge, saying that person must be vaccinated. So if you can't make the decision for yourself, then the courts are now saying we'll make the decision for you. And in particular in care homes, given the enormous number of deaths, of course, last year, the courts are taking what I think is probably an understandable view, which is get them vaccinated. Whether employers can insist is outside the sort of circumstances we talked about. On vaccination, I think is a very moot point. I think it's an invasive requirement. The health minister has said we won't mandate it, but as so often the government says, with the one hand we won't ask you to do that, but with the other hand that it says we'll advise you to do it. My sense of it is that employers would have to tread carefully before being too heavy-handed about these demands. And as Laura said, I think it'll be about risk assessment. It'll be about whether, for example, other steps, for example, proper social distancing, in offices, the use of bubbles, PPE, availability of sanitizer, and so on, whether those other steps that will be taken under a proper risk assessment have been taken and can give employees the right comfort that they deserve, regardless of whether vaccination is insisted upon.
Thank you, Paul. That obviously another shot of wisdom, so thanks for sharing that with me. Just to let everybody know that the questions have been coming in. I've got another 1, 2, 3, 4, I think 4 or 5 questions in, maybe 5. So if you're feeling up for it, type away. We'll maybe try squeeze in another question or 2 at the over and above that. So if you're holding fire, then this is the time to do it. I'll keep Paul on for the next question. It's quite a short one actually. It says, what's the difference between direct and indirect discrimination?
It's a good question, John. Direct discrimination we don't see as often, but it's pretty straightforward, hard to describe, but straightforward to spot it when you see it, like an elephant. If you're treated badly because of a protected characteristic, so we've already talked about religion and belief, but sex, race, disability, then that's direct discrimination. If an employer says, I will not promote you because you are a woman, or you will not get the same training opportunities as somebody else because of your ethnicity, or I won't make available suitable adjustments in the workplace for somebody whose disability requires reasonable adjustments, then again, actually reasonable adjustments is a bad example, ignore that one. But somebody who, for example, is dealt with on the basis that because they've got a disability, they won't be able to do certain things. So an employer making stereotypical assumptions about that person's ability because of their disability, those are all examples of direct discrimination. Most employers don't do that overtly. They know that they're going to get reputational damage and potentially large financial damages awarded against them if they are overtly discriminatory. So most cases that we see are not direct discrimination cases. There might be harassment cases. I won't deal with those specifically. Let me talk about indirect discrimination. So indirect discrimination happens where an apparently neutral practice by the employer disadvantages one group of people with a protected characteristic. So that's best shown by an example in relation to, say, full-time working. So it's well known that many women returning from maternity leave look to vary their ordinary full-time contract to say, can I return for childcare or other purposes on a part-time basis? So if the employer says, no, we require everybody to work full-time, then that's not direct discrimination because that's gender neutral. The requirement to work full-time applies to men and women. But in fact, because of childcare responsibilities, and the courts currently accept, and the evidence seems to show, that the preponderance of childcare responsibilities still falls to women, then that kind of criterion will have a disproportionately adverse effect on women compared to men. So that creates, we call it a barrier in some cases. Does the employer's practice or requirement have a barrier effect that means that an individual can't do what they wanted to do? So one example is full-time versus part-time working. Another example would be in relation to years of service in age discrimination cases. So it's potentially neutral to say we require you to have 10 years service to be promoted. But in practice, of course, the reality is that anybody under 25 probably doesn't have 10 years service. So whilst it might be neutral, a tribunal would be prepared to look at it and say younger people would be less likely to be able to comply with that sort of requirement. So that might be indirectly discriminatory. And it can work in age discrimination cases at the other end of the scale too. In one case, an employer imposed an obligation on promotion to have a degree. And I think it was a police officer, in fact, was able to show that because of his age, he was in his 50s, that or 60s, that back at the time when he would have gone to university, many fewer people did than were doing so in the last 10 years. So the ability of older people to meet that criterion was reduced simply because of the availability of access to university education. So again, that could be indirectly discriminatory. And the last example I'll give is qualifications, requiring, so the degree is one example in relation to age, but in relation to sex, requiring an engineering qualification, for example, might be discriminatory on the basis that most engineering degrees are done by men. Now, Laura made the point earlier that the law is not entirely blind to the realities here, and it may be in these cases that the employer, whilst on the face of it guilty of indirect discrimination, can justify what they're doing. So they may say, for example, that we're engineers and we require you to have an engineering degree, and that might well be a good reason for putting that barrier in the way. But whilst it might have a disproportionately adverse effect on women, nevertheless, there's a good reason for it, because we want our engineers to be properly qualified. But what the law expects is employers to look carefully at whether their practices do create barriers to entry, if you like, and they can do so sometimes in indirect and unexpected ways.
Thanks, Paul. I'm still jealous with that sunshine in your back garden there, like, but never mind. I'll save mine for tomorrow. And Laura, is there anything you want to add to that answered question?
I think Paul's answered that very fully. I don't think there's anything else I can add. Good.
So the questions have been coming in, which is good, and we'll try with, what time is it now? It's I'll be the time clock at 6:26, 6:27. So still got time to answer a few more. So thanks everybody for participating. So the next question is to you, Laura, and it's my employer wants to make changes to my contract of employment. What are the legal protections for this person?
Okay, well, the first thing I would say with regards to that is that good practice from an employer would be to consult with the employee. If there was a number of people that were going to be making changes, consult with the trade unions for that organisation and offer an opportunity for a mutual agreement of that change of terms and conditions rather than just enforcing it. Now, I say that quite often there isn't that mutual agreement, you know, that there isn't that the employee isn't always happy about the potential changes that are being imposed upon them. So then, I mean, there's a couple of ways really that an employer can change the terms and conditions of your contract. One of those is by kind of unilaterally giving lawful notice of those changes, and they can do that. The issue with this is if the employee doesn't agree, technically the employer could think, well, I'm going to terminate that contract, but depending on the situation, that could then potentially be unfair dismissal. And I'm saying depending on that because it really, really depends on the individual situation and what would be classed as a reasonable change and what wouldn't really. If the organisation's got a good business reason to change someone's terms and conditions and they can argue that, then that would be reasonable. If they haven't, then there potentially could be an unfair dismissal if an employee refuses to engage on those new terms. And that ultimately is for a tribunal to consider. Now, if an employer decided to change the terms, change the terms and conditions of your contract and you were given no notice and the change was actually a significant change, then there's a potential breach of contract because they haven't given you the notice for change there as well. So again, it's about talking through those individual situations with the individual to actually establish what is going on. And quite often we can support members to raise grievances about those potential changes, have one-to-one consultations with management about those changes and whether we can negotiate something better effectively for that employee. The one thing I would say is that actually if someone isn't in agreement of the changes, then you need to make it clear that you're not in agreement to those changes of your terms and conditions. Because if you carry on working and don't make that clear and then decide you want to bring a claim to tribunal, but you haven't clarified that you're really not happy about this change, it could be viewed that by carrying on with those new terms and conditions, you've impliedly agreed to them. And so that wouldn't be a successful claim. So again, without knowing specifics, it's quite difficult, but I really strongly urge people to contact the team to discuss those, situations individually, and we can advise you as to how to go about, getting the best change for yourself, I suppose.
Yeah, thanks, Laura. And of course, once more, the opportunity to join a trade union and a professional association. If you're not a member, then certainly you can hear the questions being answered for further advice. There's other unions available also, so I must get that in as well. Paul, would you like to add anything else to the question about the changes to contract?
Well, it's very topical, isn't it? The British Gas employees are, I think, today about to be fired for refusing to accept pay cuts and diminution in their terms and conditions from a company that, by all accounts, is profitable. So we've got this whole issue of fire and rehire, as it's been described by the politicians, and certainly the trade union movement. It seems very much behind the Labour Party's idea that we should bring fire and rehire to an end. These cases are really difficult. People say to me, and I've always said, I've got a contract, I've worked in this job for 10, 15, 20 years, I do XYZ work for these terms and conditions. How can my employer simply come along and change it? And I get that, because it seems ridiculous in a sense that one side to a deal can unilaterally look to make changes. But as Laura has described, the reality is that the law allows, as a last resort, an employer to fire and rehire on the new terms and conditions. And if that happens, you've no case for breach of contract, because if you accept the new job, then you've signed up to the new terms and conditions, which is what British Gas is asking its employees to do now. Your old job's gone, here's your new contract. The moment you sign up to it, you've accepted the new terms and conditions, so you'll have no complaints that your employers are in breach of contract. You might have an unfair dismissal case, but those cases are difficult and time consuming, and they're not guaranteed of success, and the compensation that you'll recover at the end of them might not be great either. So I'd endorse John's view there. The best way to try and get somewhere with that, join a union, act collectively, see whether industrial pressure can be brought to bear, and see whether a deal can be negotiated, because in most of these cases, negotiation is more effective than litigation.
Thank you, Paul. I'll move over to the next question here. I'm multitasking between screens, and I can see it saying, I'll do my best articulation for this one. It's quite a long one, so bear with me. It says, can you advise on what the best processes would be to formally make a complaint about the way a case is managed? It's a high-risk case, and I've raised issues with my own management, who are usually fantastic, but there's no movement. I'm at the point where I really don't feel comfortable working the case due to management decision making or lack of it. Is that okay, Paul? Would you like me to reread it?
No, I've got that, John. I'm not going to talk about the professional aspects of that. I think Laura could probably deal with that in terms of the practical side of it. The legal issue that it potentially flags up for me is whistleblowing. So you are protected not just from being dismissed, but also from any other detriment that your employer wants to inflict upon you, if the reason for that is that you have blown the whistle. And it seems to me that the question that you described there implies that it may be that there's a matter of public interest, a serious case where perhaps there's an element of public danger, where things have been brought to the attention of the employer by an employee, and that's a classic case where whistleblowing protection can be invoked. Again, it's another classic case where if you've got a trade union behind you, go and talk to your trade union rep and get representation and get the union to approach the employer on your behalf and make the point early in the day. I believe that the remarks I'm making amount to public interest disclosures under the whistleblowing legislation, and I'm therefore protected from any attack by you because I've simply raised those things. You have to be careful about the procedure you adopt. I won't go into it here, but a union will advise you about how to do it. Essentially, you must go internally at least to start with. Going direct to the press is the wrong way in nearly all cases in which to do it, and you might lose all of the protection that the law provides to a whistleblower if you go about it in the wrong way.
Thank you, Paul. And Laura, I'm sure you've never experienced any questions like that from members, but any sort of brief advice on that one regarding the feeling uncomfortable with the case?
Yeah, I mean, I would echo what Paul said in terms of the whistleblowing issue. I mean, whistleblowers in theory are protected by the law, and the law is there to protect whistleblowers. I think it's very important to get hold of your organisation's whistleblowing policy, so that if you wanted to raise it via the whistleblowing route, you're quite clear as to if there is a policy, what you can do to raise that as an issue. suppose the thing I would say is that I will stand here and quite clearly say that people are protected by law. In reality, life can be very difficult for a whistleblower. So I just want people to be aware of the realities of being in that situation. And I don't doubt that this person asking this question is probably aware of that, because they're asking the question anyway, you know, in terms of what can I do about it, and thinking about their processes. I mean, as Paul said, it's more of a practice issue rather than an employment issue. But from a social work practice point of view, I think it's about looking at making sure that any concerns that you have raised, you've done so in writing and not just verbally. So you ensure that you're doing so via email. And actually, if you're not getting anything with your manager, is it worth escalating this to higher management? Because one of the things we see as representatives when we're representing in Social Work England is people will say, well, I told my manager about it, and the regulator will ask, well, why did you not go higher than that? Why did you not escalate it any further? So I think that's something that's worth thinking about in terms of how you have escalated it and what you've done, and how you can evidence that you've done that, because ultimately it comes down to you being able to evidence that you've done what you can, you know, in terms of that case. And you know, those concerns come down to, I have no idea what case this is, whether it's in children's practice, adults, you know, adult social care practice, but what are the particular concerns? Is it against, you know, recognised good practices? Is it against any particular legislation? Because they're the things that we're feeding back to management, if you think that's the case. And again, I would urge you to kind of get in touch with us, because at the moment this is more of a practice issue than an employment issue. You need to consider your Social Work England professional standards and what your duties are in terms of reporting things with regards to that. But it potentially, if it does become a whistleblowing issue, then it becomes an employment issue, and our team can offer you advice and guidance on that moving forward.
Thanks, Laura. And I'll just take you, I'll take Paul back, that just to show that we're live, that questions are coming in. And if somebody's asked about, I think it's got to do with the employment, the contract changes, Paul, and the person's asking, do these changes need to be in writing, or can they be done verbally regarding contract changes?
Yes, so good practice requires that employers should ensure that any changes to contract are communicated in writing. And you could ask your employer for a statement of your terms and conditions, and if they change, you can ask them to update that as well. But some employers will make changes that aren't recorded. I still see people who've not had a contract of employment after 20 or 25 years in employment, and especially, but not only, smaller employers can be guilty of that. And I go back to one of the things Laura said. What you have to be careful about is that even if a change is not made in a formal way, in writing and with your signature, nevertheless, if it's implemented and if you work along with it, and especially if you do that without protest for a longish period of time, then it may well be that later on a court or tribunal will say that you have acquiesced in the change that the employer's made. So my advice on a practical level there would be, if the employer is looking to make changes, but is trying to do it on an informal basis, then don't rely on the employer to reduce it to writing. Do it yourself, either by yourself or by your union. Put your position in writing to the employer and make it really clear that you're not accepting the changes that have been proposed. There's this idea that you can sign a contract. This is worth adding, I think, actually, although it goes slightly off piste. But there's an idea that you can sign a contract and say, I'm signing it under protest, and that'll be all right. And my advice to you is, don't do that. Certainly not without getting advice from your union or your lawyer first. If you sign it, chances are that a tribunal later on will say, well, you signed it, you've agreed to accept the changes there. And your argument may well be, well, what alternative did I have? The boss was saying, if you don't sign it, you'll be sacked and you'll be out on the street. And I've actually heard a tribunal chairman say, well, there was an alternative. The alternative was to be sacked. And then you could have brought a claim to an employment tribunal, so you had a remedy. So it's not nice news, but I think it's very useful to know that don't ever sign a contract unless you're sure you want to be bound by what it says. Signing it under protest, to my mind, is rarely an advisable way to go.
Thanks, Paul, and hopefully the person asking that question is satisfied there. The next question actually is to you, Laura, and it's quite topical actually. It's about supervision, and the Social Workers Union announced this week that we'll be doing a massive piece of research with Bath Spa University, looking at the impact to supervision over COVID, but also looking at suggestions about what reflective supervision should look at. So please look out for that research. We're working on that in the next 3 or 6 months. So Laura, the question to you is that somebody's saying that because of COVID, informal supervision side of things is presently lost. That makes formal supervision very important, obviously, but what if this is not satisfactory? What can I do about this? How can I raise it? So if you're happy to answer that, Laura.
Yeah, I think, like you say, John, it is quite topical. And I think sometimes with COVID having happened, things have fallen to the wayside. And I get how that happened initially, but we're kind of getting used to living like this now, aren't we, unfortunately? And so, for a year later for supervision to have fallen by the wayside, I don't feel is acceptable as a general practice issue, really. I think in terms of raising it, I mean, the first thing to do, I would say, is to raise it with your manager, who you're not having the supervision. And again, I'm a real stickler for doing this in writing. It may feel quite formal, but actually, unless you've got the evidence that you've tried to raise it as an issue, there is no evidence of it. It's one person's word against another, really. So I do think it's important to put that in writing to your manager. Just drop an email, say, look, I haven't had supervision for a long time. Can we organise something? I'm really concerned about the fact that I'm not getting my supervision, and it's important for me as a professional and for my reflection. And I think it's always better if you can try and manage those things informally first with your manager, because at the end of the day, if you're working underneath the manager, you need to have that working relationship with them, and to start raising formal complaints and formal processes makes life more difficult. Now, I'm not saying don't raise that, but always try and do things from an informal perspective first is what I tend to advise people. I think if you're not getting any joy with that, I would be looking at checking out what your organisation's actual supervision policy is, because if it says that you're supposed to have supervision every month or every 6 weeks and you're not having that, you could quote that in your email. And sometimes there's things in your contract about that you'll be supervised by somebody, so it's worth checking out that documentation, but particularly referring back to the supervision policy and raising that with your employer. If you need to, you can escalate it higher, talk to your manager's manager, and again, I would kind of give us a call at that point if you're not getting that resolution to talk about maybe raising an informal or formal grievance is appropriate. But that really is, to me, a last resort, because you want to have that working relationship with your manager moving forward. So I definitely think raising it with your manager in the first instance is key, because actually sometimes doing that does just solve it. But make sure whatever you do, you have it in written form as well, because I don't know, say this is worst case scenario, but if in 6 months down the line they're saying that there's issues with your practice, but they haven't supervised you for a year, well, there's quite clear evidence there that they were happy to leave you without that supervision for a year, and yet they're now raising the concern. So that then falls back on a bit of the employer's responsibility as well for offering you that supervision. So yeah, make sure everything's written down.
Yeah, thanks, Laura. And I take it we often get asked that question quite a lot from social work students regarding the lack of supervision from practice teachers and practice educators. So again, I think your advice would be really it's part of a formal contract, isn't it, for that supervision session? So to make sure that's noted.
Yeah, absolutely, 100%. And I think it's particularly important for social work students. And I think again, during COVID, being a social worker, a student on a placement, I recall many years ago when I was doing my training, actually physically being in an office with staff around me who I could shadow, pick up on things, you pick up on all sorts of different kinds of practice, all sorts of different things. You're not doing that at the moment because everyone's working from home with COVID. And I think that's where the supervision at the moment, particularly for students, it's very important for students anyway, but when they're not actually getting that face-to-face interaction with the rest of the team, I think it's essential. And absolutely, I would raise it in writing, to my practice educator at that point, practice supervisor. And if that is still not happening, then you may want a conversation with your university tutor, who's often, kind of around offering that supervision as well.
Thanks, Laura. And Paul, any words of wisdom to add in relation to that question?
Laura's answer's really good. It might just be worth fleshing out two things that arise out of it. Firstly, just to reiterate Laura's point, put it in writing. By the time you end up going to your union rep, and even more by the time that your union refers you to a lawyer for advice. What we want at that point is evidence of you raising issues with your employer that they didn't tackle. And telling me that verbally I spoke to my manager in September and December, and then in January I rang them, is fine, but it's nothing like as good as producing the emails to me and saying, here's the evidence that it happened, and there's their reply. And sometimes a failure to reply can be just as effective as a weapon in our hands as a reply that's unhelpful. So, secondly, just be careful about how many of those you send. I think this is probably not said often enough, but I'm sure you've seen it. It can become almost a second job, making these complaints to management. And one of the things that tribunals do, because they're all human in the end, is they look at the degree to which perhaps you might have become a handful to manage. And that's the truth of the matter. And if it is an email a day saying, my email yesterday refers, and if your 60th email has got 12 pages of appendices, then take a step back and say, am I really helping myself? If you've got early advice from the union, they'll be saying this to you, and they'll be giving you a steer about, when's the time to send the next email. But all I'd say is bombarding is nearly as bad as putting nothing in writing.
Thank you, Paul. And we've got about 15 minutes left, and with maybe 4 or 5 questions, so we're doing well, and we should manage just to fit them in. But if not, we're hoping to run this session again. It's very popular, and obviously you can watch it again, and also encourage your colleagues to watch it. So look out for it. Paul, this is quite a long question, so I'll take my time. I'll do my best to present it to you. It says, what are your rights with regards to a secondment for your development? My manager stopped my application as there was no backfill for my post. Another staff member has been on secondment for 18 months now, but not due back until September. So she said I can't go on secondment too. I was shortlisted for the interview and I have to withdraw my application. It was for a team manager 12-month secondment, and I am a senior practitioner. So the person's looking for the rights regarding that.
Yeah, thanks, John. It's one of those that begs half a dozen other questions, and somewhere along the line there, perhaps it's something that can properly be raised with a rep if you're a union member, because there are some additional answers that I'd need. But let me make a few sweeping assumptions, and hopefully I can say a few things that might shed some light on it. The first is that ordinarily, and I don't know about your contract, but ordinarily your contract won't provide you necessarily with any guarantees about development. It's very much a matter for managerial prerogative and discretion. So it's unlikely in most cases that you're going to be able to say, I have a contractual entitlement to XYZ in terms of my training and development. So that's the first thing to say. If the contract's different and says and gives you an entitlement of some sort, then that's the place to start. To say to your employer, I've got a right here, my contract says this, you're breaking my contract. Secondly, and be careful because this is a nuclear option, but if the other person who's been granted the secondment and you've not is a man and you're a woman, or is white and you're black, then potentially you're being treated differently on the grounds of a protected characteristic. So think about whether there's discrimination at work here. But I'm not seeing that as a question where that arises. I'm sure you would have said something about that if that was part of the question. So where does that then leave you? Obviously disappointed. Applications had to be withdrawn despite shortlisting. The reality is that absent discrimination, absent a contractual right, probably you've no legal remedy. And it's disappointing, I know, but the law is really bad at managing what happens during the currency of an employment contract, unless there's discrimination at play, when it becomes, as I say, a nuclear option. But courts won't interfere almost ever to try to require an employer to behave in what might be a perfectly reasonable and good and sensible fashion and in accordance with decent practice industrially and so on. A court won't interfere because realistically it can't, because it can't manage the relationship. So that the only thing likely to be available to you, if the other avenues I've mentioned are not open to you, will be to think about whether what they've done has so undermined your trust and confidence in the relationship with them that you could walk and say, I've been constructively dismissed. Now, let me just take a minute, if I can, John, to say a word or two about constructive unfair dismissal. You're constructively unfairly dismissed where your employer breaches your contract in a really serious way, and where you resign and say, I can no longer tolerate working with my employer. You have to do it quickly. You have to resign in response to the employer's breach, and the breach has to be, we lawyers call it fundamental. So a minor or trivial issue won't be enough. The circumstances you described do not sound to me to be serious enough, enormously disappointing, though I'm sure they were, to justify constructive dismissal. And generally, I want to say this about constructive dismissal cases. I've got loads of clients that I've seen, hundreds over the years, who think they've got great constructive dismissal cases. And what they all have in common is that none of them do. And if you take nothing else away from what I've said tonight, but that constructive dismissal cases are almost never the way to try and resolve matters at work, that I've done my job.
Thanks, Paul. I'm also aware of the time. I think we've got 9 minutes left, but unless you've got anything you want to add to that, Laura, will I move over to the next question? Are you okay? So I'll keep this one for you. And again, it's came in here, and we've got a few questions. It looks like we won't get through them all, but this one says, as we come out of lockdown, can a company insist that I continue to work from home?
Who's that one aimed at, John? Paul or me?
Oh, sorry, that's for you, Laura, if that's okay.
Sorry, that's why I was silent. I think this is a difficult one because, again, it comes down to that change of terms and conditions and, change of your contract. And actually, for some people, they may want to actually continue working from home. And I know for a lot of people, it's worked quite well, probably more so when the kids are at school than when the kids are off school, I have to say, in my experience. When they went back a couple of weeks ago, I was much happier. But I think for a lot of people, it has worked quite well in terms of being able to work a little bit more flexibly, not having to travel for, sometimes people commute quite a long way to get to the office. But there are a whole host of issues with working from home if you're not generally set up to work from home. Most people don't have a luxury of a spare room with a desk set up, and so that there is all those practical issues. So whether they can force you to continue working from home, again, comes down to that negotiation around contracts and changes in your contracts and terms and conditions. And ultimately, I suppose if the organisation has a business case to say, well, actually, we don't need staff in the office anymore, and we don't actually have the office facilities for people to work, potentially that could be viewed as reasonable by an employment tribunal. I'm thinking further down the line, and again, we don't know this. But what I would say is if an employer is insistent that they work from home, they do have to provide you with the proper equipment and facilities to be able to do so. So for our team, we've always worked from home. I mean, this year we've worked exclusively at home and not done face-to-face representations, which has been very different to what we're normally out and about physically representing people in meetings. But, in terms of our setup, it's part of our requirements that we all have to have a proper desk. We can obviously get our own desk, but Basil will look at providing that if we want them to, but it ultimately belongs to them at the end of the day. So your employer could purchase you a desk, but if you were to leave the job, you'd probably have to give it them back. IT equipment, chairs, if you need a particular specialist chair, etc. All of those things need to be thought out. They can't just, it's not good practice to give you with a tiny laptop that you're looking at on your dining table long term. That's not good. You're going to end up with back problems, neck problems, etc. So there's all those things to iron out. And if you're really unhappy about working from home, and I know I keep saying it again, I would say get in touch with our team and we can talk you through what you could potentially do to challenge that, and whether ask the employer whether there's any leeway about that in terms of them offering you spaces in an office facility, etc., really.
Perfect. Anything to add to that, Paul?
No, I think that covers it really well. Good.
So I'll just move on to a next question, Paul. I'll aim this one at you, and I'm just reading it here. It says, in fact, let me see this. This will probably be the last question for you and Laura. Apologies for any other questions we've not answered, but If you are a member, then obviously there's there's a duty service at the advice and representation team, and there's a link there. So if it's important to you and you feel that we can assist, then please use that process. If you're not a member, then please do consider joining up. You'll find some of the links on the BASWA homepage, and you can look at it there. So Paul, I'll go back to the question that says, my organisation is going through a restructure of jobs, of job families, job descriptions, pay scales, etc. They're looking at the entire organisation under the Green Book, and we'll explain that later on, Paul. Unison are involved in the discussions. Is there anything we should know about this kind of restructure? Is there any advice that we can provide? Or is that okay, Paul?
Yeah, I suspect that SWU can say something about that, or BASWA too. It's a huge question because by the sounds of it, it's a huge restructure, but it kind of goes back to what we've been talking about in terms of changes to contractual terms. When the whole organisation is undergoing a restructure like that, then it can be really quite difficult to resist those changes. Making representations to the employer, often via the unions, if that can be done, is often the best you can do. The employer in the end is going to say to a tribunal, if we try and contest it legally, we've looked at the whole business and we've got a whole set of business reasons why we want to make these changes to job descriptions and pay scales and so on. And if there's a reasonable business case for that, and it might be a financial case, and which public services don't argue that they're cash strapped at present, then tribunals often won't look behind that. They'll say managers are entitled to manage, to make the changes. And often, as I said a while ago, trying to get your way out of this through a legal process is going to be difficult, expensive, time consuming, and quite possibly unsuccessful. So to get involved with a union at the earliest possible stage, get your voice heard, get together with as many people as possible. And again, that's what the union can do best when it works collectively, to make representations to say, don't do it in this way. And if you can put forward those representations in as clear a way as possible, and that, again, talking before about reducing things to writing, that might then be evidence that later helps us with a legal case. But actually negotiating a better result from the restructure as part of the process is nearly always going to be better than trying to resort to lawyers after the fact.
Thank you, Paul. And Laura, any final comments on that last question?
Just one, I think, very quick thing to highlight to members is that normally our social worker union isn't often involved in the collective bargaining, as in recognised for collective bargaining by employers. So this is why obviously somebody's mentioned Unison are being involved in that. But what I would say is that what our team do is we offer people representation in individual consultations, and normally as part of a restructure process, there are individual consultations, and we attend those with members. And I have to say we tend to get far better results from those individual consultations, because we can really negotiate a better outcome for individuals with regards to the restructures, and they're really important. So if there is a restructure going on and you're offered an individual consultation, as long as you're eligible for representation from us and you've been a member for more than 3 months, we can attend those and offer that representation to you. So I'd urge you to get in touch with us.
Thank you, Laura. And I'm always impressed after these sessions, because there's so much knowledge there, and really, I suppose you guys have answered right on the spot. So, so I would just finally like to say thank you. And Laura, Paul, any final comments? You have 1 minute left. Anything? Good night to everyone.
Yeah, well, thanks everybody for coming. I've seen that we've gone up from 25 at the start, I think, to 37, 38. It's always encouraging when the numbers go up and don't go down.
Yeah.
There's nothing worse half an hour in when everybody starts fleeing the room. So just thanks to everybody for being so polite and staying and listening, and I hope you got something out of it.
Thank you. And Laura? My
final comment would be 100% join a union, and of course I firmly believe that the social workers union is the best one to join. But other unions are available, as John says, and being a union, it makes such a big difference. And having done this job, I've seen the difference it makes to people.
And how do I follow that apart from saying good night, everybody? Thank you for watching and for listening. Bye now.